Generally, you cannot change the settlement agreement after you get divorced. And the reason for that is, you just spent this great amount of time litigating or negotiating to try and reach a settlement, and you need to testify to the court that you believe it is fair and that you understand it before the court will put through your divorce. If you come back a couple of months later and say, I didn't understand, the court is going to call you out on that and say, you were questioned about your understanding of this agreement. Why are you changing your mind? Now, circumstances could change that could perhaps make enforcement or the strict reading of the settlement agreement unreasonable or impractical. A good example might be if, for example, one spouse had 6 months to refinance the mortgage and pay the other spouse their due from the marital home, but if they were unable to get refinancing, they couldn't qualify, unable to get the loan that they wanted. We don't change the settlement agreement, but what we do is modify that term to say that instead of 6 months, perhaps we negotiate they have now had 8 months to accomplish refinancing. Or if that simply isn't practical, then the house needs to be listed for sale. But generally, that what-if scenario is going to be addressed within the marital settlement agreement. If there's any question about whether or not one of these terms is going to be accomplished, there's generally a backup written into the agreement so that we don't have to keep going back. You don't get a second bite at the apple, as they say, to renegotiate the settlement agreement that you originally negotiated. So a settlement agreement is only something that you negotiate and that you actually agree to. So there shouldn't be any reason to change that settlement agreement after the divorce is over.